Hi, I'm Steve Richardson, and welcome to the June 2019 episode of Lunch with a Lawyer. And today we're going to talk about something that a lot of people don't know about, and it's one of those things which you don't know can hurt you a lot if you're a public employee here in New Jersey. And that has to do with something called public employment forfeiture. And that can happen if you're convicted of certain minor offenses. I usually deal with traffic court matters, things that are handled in New Jersey's municipal court. In other states, you've heard the terms felony and misdemeanor. Well, we don't have that terminology here in New Jersey. Of course, New Jersey has to be different. And we don't call them felonies and misdemeanors. We call them crimes, disorderly persons offenses, and petty disorderly persons offenses. Now, the last two are our version of misdemeanors. So we have crimes and disorderly or petty disorderly persons offenses. The latter two are handled at the municipal level in a municipal court. And things like shoplifting, simple assault, some not so serious or indictable crimes that would be handled at the county level. I don't get involved in that. So what I see, and a problem I see in these minor crimes, minor petty or disorderly persons offenses, that they can have this little trap and what's called a collateral consequence. So let's get into it a little bit and what job forfeiture means to the public employee. Now, as I said, if you're convicted of one of these offenses, you don't lose your job. The judge will sentence you and say, all right, I find you guilty of shoplifting, for example, and I therefore sentence you to this. And there are sentencing guidelines for that offense, for shoplifting. So that's it. Case is done. You leave court, and that's the end of it. And then later you find out that you're going to lose your job. And it's called a collateral consequence. It's a consequence of the punishment of the conviction that is outside the sentencing guidelines and collateral to that finding. So what happens is it's a collateral consequence. Now, what is public office? That's the first question. Well, public office is defined in the law very broadly and includes all elective offices, as well as full or part-time employment with local, county, or state government, school boards and districts, fire districts, authorities, and any other political subdivision of the state of New Jersey. So, pretty much any public employee is subject to this collateral consequence. So, you got to look into it carefully. Now, how do you know if you risk this consequence? Well, if the job fits your description, you have to look at the offense itself. So there are two instances in which this can happen. The first is if you're convicted of an offense that involves dishonesty. Okay, so shoplifting, something like that, dishonesty, and it's not dishonesty is not specifically defined. But I said it would include something like shoplifting, receiving stolen property, theft by deception, things like that. And this is because dishonesty is at the heart of all theft offenses under New Jersey law. So, as I said, then there's lying to the police, hindering an investigation, which again is lying to the police, or passing bad checks. Okay. So if it involves dishonesty. Okay. And the other is if you're convicted of something that involves or touches upon your public office or employment. In the first instance, if it is a crime involving dishonesty, then you face losing your job. If it is an offense that involves or touches upon your public employment, the consequence is actually worse because you can be banned permanently from public employment anywhere in New Jersey. I'm talking about federal employment, but this is under New Jersey law. Okay, so a lot more serious. You lose the job you have, and you can never have public employment after that. Involvement in employment is not always self-evident, okay? And municipal court prosecutors are on the lookout for this. And they're being instructed to investigate forfeiture issues and see, are you a public employee? Is this something that needs to be reported as part of the plea? So if it happens and touches upon your job and you commit this offense while working, during working hours, that's one thing. And it's kind of obvious in that instance. Take simple assault, for example. A teacher loses his or her temper in the classroom and strikes a student. Well, clearly that is a disorderly person's offense of simple assault that touches upon the employment. It happened in the classroom. That's pretty obvious. But what happens if you're with an off-duty police officer, for example, or a teacher at a family gathering? You're off duty. You're not actively working. Well, how does forfeiture come in that instance? Well, the New Jersey Supreme Court has actually weighed in on this, and they say that forfeiture for off-duty misconduct may be ordered when the infraction casts a shadow over the employee. In effect, something that would make the person's continued public service appear to be incompatible with the traits of trustworthiness, honesty, and obedience. Okay, so that's some fairly broad language, as you can see, and oftentimes you see in the news where public employees, or usually politicians, are accused of offenses like this, and a lot of times sexual harassment, that's been in the news a lot, and some things where they, that can happen, and where that now everybody knows about it. It's not something that happened, like I said, at a family gathering, but it doesn't make the news, or it doesn't get into the public square where people know about it. So the statute states that off-duty misconduct must have a direct and substantial relationship to the governmental position that is subject to forfeiture. So the statute gives us a little bit more guidance and focuses in that general language from the New Jersey Supreme Court. So that conduct has to have direct and substantial relationship to the governmental position subject to forfeiture. So you have to put. Now, that's when it's triggered. That's how you know you're potentially facing it. So, all right, Steve, I've committed one of these, I'm accused of one of these offenses. I'm worried about losing my job. What do I do? Is there anything I can do? Well, yes, there are some steps you can take, and I urge anybody that is watching this video, that if you are accused of an offense that touches upon dishonesty or touches upon your job as a public employee, get an attorney. Have that attorney, make that attorney aware of the situation so that he or she can take the appropriate steps. Because there are a couple things you can do. The first is obtain a forfeiture waiver. So, all right, you go into court, you're facing a collateral consequence of public forfeiture, okay, of your employment. Now, this is where forfeiture that would result from a plea or conviction of a disorderly or petty disorderly person's offense can be waived upon application to either the county prosecutor or the attorney general. All right. Now, this takes a little finessing. All right. It's not always granted. All right. So that's a step you have to take. You make the application. You make sure you check that box. No. Okay. It's not always granted. It has to be based on a showing of good cause. You have to give a good reason why you shouldn't lose your job. And this must be handled carefully. And it must be done after the plea deal is agreed to with the prosecutor, but before the plea is entered and the conviction is given by the judge. So you go into court, you make the deal with the prosecutor, say, okay, I'm going to need an adjournment for court, come back later, I need to make an application for a waiver of public forfeiture, and then if I'm granted that, then we can come back into court and we can put the deal through before the judge. So again, it has to be handled carefully. You have to plead your case to the county prosecutor or the attorney general that you should be granted this waiver. That's one of the two ways around it. The other is You could plead to another offense. A lot of these cases can be plea bargained. And this can depend upon what judge you're in front of, the prosecutor, the court you're in. Different courts and counties around New Jersey do this, or some are more receptive to it than others. But for example, if you face a charge that involves dishonesty, such as shoplifting, then perhaps they might agree to a plea downgrade to trespassing or something like that. You were trespassing in the store where you shoplifted. Or maybe a municipal ordinance. If they pleaded down to a municipal ordinance, then that isn't subject to public forfeiture because it's not a disorderly persons or petty disorderly persons offense. It's a municipal ordinance. But prosecutors are not. That's a difficult sell these days. To get it down to an ordinance, there is something called a conditional dismissal that's available for things like shoplifting and other nonviolent crimes that are minor offenses. And if you're eligible for that, that can be another way of getting around the statute, the public forfeiture. Now there's and it may seem kind of odd, but there's conditional dismissal, which is a mechanism of what's called diversion. It's part of an overall portfolio of options. If this is your first brush with the law, you're ordinarily a law-abiding person, and they give you your one bite of the apple to get out of trouble. You can never use it again in any context. With crimes indictable at the county level, there's pretrial intervention. Where drug charges in municipal court, there's conditional discharge, and for these minor criminal offenses, there's conditional dismissal. But you may not be you might not be eligible for conditional dismissal. Maybe you already had your bite of the apple. Or you want to save that card and play it again. Just keep that in your back pocket if you ever get in trouble again. So you don't have to play that card. You're one bite of the apple. And there's something called a dismissal with conditions. It may seem like wordplay, but there really is a difference between a conditional dismissal and a dismissal with conditions. What I mean by the latter is this. Let's say you're accused of shoplifting. And what they do is they say, well, the store where you're shopping say, look, we're not that angry. We just don't want this person in the store anymore. If they agree never to come back to the store, then we'll agree to dismiss it. That's the condition. If you violate that condition, they can reinstate the charges, but it's a way of getting around it. So there are some ways to negotiate a deal to avoid forfeiture of your job. Okay, so if you're in that position, get a lawyer. Okay. If it's a town here in Camden, Gloucester, Salem, or Cumberland counties, feel free to give me a call. I'm happy to help out with it. But that's what you're facing. So forewarned is forearmed. All right, so that's it for this episode of Lunch with a Lawyer. We pretty much covered everything in our topic. So that's it. Now, if you like this video on Facebook, please hit that thumbs up button, hit the like. Feel free to comment if you have a question, or if you have a subject for another episode. Hitting that like button helps circulate the video so that other people who may not have seen it live but might benefit from this information can see it. So it helps with traffic on Facebook if you give it that thumbs up. Now, I realize the confidential nature of what we're talking about here. So if you may not need this information, but if you know somebody that might benefit from it, you don't have to post it on their wall, okay? You can actually share it through Facebook Messenger. So obviously this is not something you share out there. Hey, Joe, I thought you might be interested in this, or I thought you might be able to use this information. Don't post it on their wall. You can post it confidentially in Facebook Messenger, as confidential as anything can be on Facebook these days. But post it in Facebook Messenger. Also, this video will be posted to my YouTube channel at richardsonlawoffices.tv. That will be posted and put online sometime next week, the week of June 17th, 2019. And when that's posted, you'll be able to watch that. You can share that video on YouTube. You can and give it a thumbs up. Hit that thumbs up button. Again, it helps Google with the search algorithm to share the information on the broader web beyond Facebook. And if you liked it, give it that thumbs up. If you not only like this video, but maybe have seen other videos on my channel, feel free to subscribe. Click that blue R button over there and subscribe to the channel for more great information. Other than that, that's it for Lunch and a Lawyer. I'll see you next month.